Thank you.
Welcome, everybody. My name is Pat Weller. I'm an attorney at Monroe, Moxness, and Berg. We're located in the Minneapolis area. And with me is my partner, Tim Ring. I'm a commercial real estate lawyer, have been for over 30 years. Tim is a corporate mergers acquisition, and he's done his fair share of workouts over the years. A little bit about our firm. We have been in existence almost 40 years. We are a boutique firm, and we focus on commercial practice, corporate mergers and acquisitions, and commercial real estate. And we focus on the multi-unit industry, doing mergers and acquisitions and acquisitions of sites to be developed. We are in the QSR, casual dining, fine dining, such that it is these days, and retail sectors. And Tim, maybe a little bit about you and the M&A practice.
Sure. So my practice focuses on both M&A and corporate finance, principally in the QSR space and some casual dining elements as well. So a broad spectrum of very large deals, $30 to $200 million, and a good handful of smaller transactions ranging from a million to 10 million. So it's a good mix in the marketplace. The capital stack for deals has sale leaseback, has senior debt, and occasionally you'll see some mezzanine debt either on the acquisition side of a deal I'm doing or on the capital stack side of a deal that I'm doing.
Right. So we wanted to cover three broad areas, and just kind of a discussion between Tim and I, and any questions that anyone has. I want to give you a little bit of a legal update where since the COVID crisis has started, to see what has happened in the courts and in the legislature. We want to talk about some of the settlements or arrangements that landlords and tenants have come to in order to keep the leases in place. And then finally, kind of moving forward, what we see in the markets. Tim just spoke at the Restaurant Finance and Development Conference, and so I'm going to call upon him to give any insights he has from that conference. And then if we have time, maybe some drafting tips that we've seen, either we've done or we're hearing about, or things that are going to help everybody moving forward. And I think my initial comment is going to be that there's the legislatures in various states, municipalities, counties have tried to address the COVID issue and primarily provide tenants with some relief and bring the landlords to the table to do some negotiations. And then on the case law side, it's very thin. I think there are several cases working their way through the system. The case that's got quite a bit of attention is the Heights case. It's a bankruptcy case. And it is the general ruling from the lower court, bankruptcy court, was that force majeure, the inability of the restaurant to be open was a force majeure event, and therefore it partially excused the tenant from payment of rent. The twist, a bit of a twist, was that the tenant did have to pay rent to the extent it was able to perform in the premises. So to the extent they had catering or they did any takeout or delivery services, there was an element where they would have to continue to pay rent. But speaking of bankruptcy, Tim, I just want to defer to you a bit and give an idea of how bankruptcy works and kind of the approach of the bankruptcy courts.
So loaded question. Start with bankruptcy itself. It is the court of ultimate equity. Now, that means judges have a lot of discretion, even within the confine of a very elaborate set of rules. Judges are allowed a lot of discretion when it comes to equity and balancing the needs of the parties, be it a debtor or a creditor. But the pendulum swings in favor of the, and timelines are often extended by bankruptcy courts, allowing debtors flexibility to reorganize their affairs. So start there. That's the backdrop in bankruptcy. The rules, as commercial lawyers and commercial business people understand them, change dramatically. And that's the big advantage of bankruptcy for a debtor. But it's also very expensive. Creditors committees, debtors counsel, equity committees, advisors. The bills increase dramatically and quickly to a mountainous level, but it does afford significant flexibility for a debtor to reorganize its business and deal with leases in particular.
Right. And the only the case law generally isn't reported until it hits an appeal court, and so there are some lower court actions in process. Not many. A couple law firms are arguing that since their offices weren't open, that they should obtain some relief from the landlords or get rent back, which isn't going to happen from some of the landlords. But the other, besides bankruptcy, what's coming out of bankruptcy, the case law, there's the push, of course, on the force majeure provisions, and that is very much a case-by-case situation. Most force majeure provisions will state that force majeure, whatever that event might be, does not excuse the payment of rent. So that's been difficult for tenants to overcome. Whether or not the government action of shutting down restaurants in particular or retail establishments is a taking is something that's been explored. The issue, of course, is in the taking. Generally in a taking, there's a physical taking of the property, so you lose part of your property rights. But you don't lose, but the contract is still in place. And there's compensation from the condemning authority. And of course, in this situation, there is no condemning authority. So that I think that's been an argument that's been put forth. How successful it's going to be, I don't know. A couple of other thoughts and claims. There has been, some of the common law provisions, frustration of purpose, and impossibility of performance, quiet enjoyment. Those provisions, you should always look at your lease and see if there's anything in the lease term that may give you some ideas and some defenses if you're not able to pay rent. But I think that their property law concepts and how COVID has affected leases and businesses isn't a direct property taking or a property law. So you're kind of trying to fit a square peg into a round hole using common lease provisions in order to get relief for the tenant. As we mentioned, the legislatures have tried to attempt to help tenants. New York, California, North Carolina, all kinds of different approaches. Moratorium on evictions. I think Illinois also has one. And different frustration of the landlord's ability, if you will, to perform an eviction. The issue, though, is that the eviction, again, is the property element of your lease. The contract element still exists. So, and usually the payment of rent is an independent covenant. So the question is, even if you cannot be evicted, if you've gone beyond a cure period in your lease with respect to the payment of rent, then there may be some difficulty in curing once the moratorium is lifted. And many of the moratoriums have been extended, but there still is the issue of what happens to the rent. And kind of piggybacking off of a little bit of what Tim said, is that bankruptcy court is the court of ultimate equity. And I think that some of the bankruptcy rulings or approaches work well in settlement and or negotiating the lease going forward. Because I think anything that comes to the court because of the lack of case law and precedent, my feeling, and Tim, let me know what you think, is that courts are going to look at these situations on somewhat of an equitable basis.
Correct. It's case by case. We're seeing bankruptcy as a toolkit, but we're also seeing the rules of bankruptcy apply in kind of out of court restructures, and parties using that as guidance to do a much less expensive reorganization. How is cure going to occur? Is it kind of under a reorganization plan? Is one common tool that we're helping clients through. So you get to the right results, people retaining their businesses and their locations, if they're willing to try. And most landlords are accommodative to that, but you've got to have a business owner stepping forward and showing some kind of traction towards a result that both parties can live with.
And some tenants, especially major tenants, took a very aggressive approach to COVID and sent letters out to all of their landlords saying, we are automatically going to reduce our rent by 75%. And put forth what their demand is going to be to the landlords. Landlords in turn obviously didn't like that approach, and so they pushed back and enforced the provisions of the lease. So the initial flow out of from March was tenants, larger tenants, being able to or asserting that they had the right to reduce the rent because of the COVID situation, and then smaller tenants being given letters from their landlords saying that you have to pay, and being very aggressive in collection. A lot of the workouts that occurred dealt with 120 days or 180 days of either rent abatement or deferment. So the difference, of course, is that if we're deferring rent, it's either gets made up during the lease term, maybe amortized over several months, or it's added to the end of the term. An abatement is that the rent is in essence forgiven, but usually the trade-off for that is that the term is extended or there's some other concession. And so, Tim, I don't know what you've seen or what have you seen in the sale leaseback area as far as some of the negotiations between landlord and tenant?
So that's been interesting, and Triple P has solved a lot of the problems on rent deferral. So where a tenant has a Triple P facility, often from the lenders of the landlord, I've seen that dynamic play out, and that has solved a lot of the problems, where you have some very small tenants that have not had access to the Triple P market for a variety of reasons. That has presented more of a deferral type of structure. I haven't seen a lot of abatement structures in the marketplace. It seems to be a snowballing event that a lot of business will have to deal with first quarter 2021, mid 2021. So it's a problem that's kicked the can down the road a little bit, and we'll have to deal with a lot of restructure activity as the market comes back.
Right, and that's, I think initially the thought was is that we'd be through this crisis in 120 days, 100, 180 days, and that clearly hasn't happened. And I think retailers and restaurants have been very creative in trying to create revenue, whether it's takeout, delivery. There are a number of restaurants that do their boxes. They'll do a pre-prepared meal for that you can purchase and then bring home family meals. And in our neck of the woods in Minneapolis, unfortunately, the outdoor seating, dining areas are becoming less and less attractive. So what we're trying to do is see what happens here. We also have had more legislative, the governor has asked for the restaurants to be closed at 10 o'clock. So there's that loss of revenue. So that, this isn't over, and we are coming into, I guess, another wave of fairly dire circumstances. And so what we're trying to do is be proactive and deal with the landlords and say, you've come to the table, we've come to the table, but what are some of the solutions that we can do? One of the reduction in base rent has been a very popular tool. And there are a number of, especially the restaurant and retail segment, a number of leases that have gone to pure percentage rent. And I think that's been a fairly equitable, an equitable solution. There are the fixed costs of the landlord, of course. And so, the common area maintenance, insurance, taxes, those are going to be hard costs for the landlord. And the landlords, in a lot of situations, have asked that those costs be paid by the tenant. And the tenant is in a position where they have very little revenue, except for, as Tim mentioned, any of the PPP loans. But there is, I think, a room for negotiations. And then, Tim, how do you think courts are going to deal with things like penalties and default interest and those types of kind of hammers that the landlord has in their leases?
Great question. So both inside and outside of bankruptcy, the general view of the courts is they abhor penalties. They don't like them, and they are often not enforced absent some bad actor type of situation. So we find expense reimbursement clauses, default interest, and any type of penalties generally not being enforced absent bad facts. A tenant trying to game a situation, right, or causing undue expense. Those are the situations where we do see those provisions being enforced.
Right, and that's and it comes down to, and I think that the courts are going to look at in your negotiations, that's helpful, just what can the tenant pay? Again, is it a percentage basis? What other things can be done? Again, back when the larger tenants were giving these blanket letters saying we're not going to pay rent based on the COVID situation, the pandemic. That isn't a very equitable approach, and I don't think that that a court would look at that favorably, nor is it a good way to resolve your issues in the landlord-tenant situation. So rather, I think landlords are asking for and probably are entitled to sales information. They are looking for, if you haven't already been obligated to provide your your financials on the guarantor, and then on the tenant itself. So Tim, how do you think, if you have a lease, a tenant, and you have a personal guarantee out there, how do you see that playing out in both the negotiations and any kind of court process?
So we've been involved in a couple of those situations. One very large, and the guarantor was able to negotiate a soft settlement with all of its constituent parties, landlords included. And the tool being used is rent mitigation. And that 10% general rule of rent mitigation, or 18 months, depending on how you look at rent mitigation, and using that tool to cause landlords to enter into restructures to allow time for a sale of a business or allow time for the remaining portion of a business to be restructured. That's what we're often seeing, and guarantors being released from their obligations so long as they're actively helping the landlord and the lenders get to the right result on a mixed basis. There does exist that other realm where landlords are pursuing those guarantors actively to cause or minimize the amount of loss on a particular transaction. So we're seeing a little bit of mixture, but the active guarantor, helpful guarantor, often faces a much better outcome.
So, as mentioned before, these moratoriums that various jurisdictions have, I would assume, Tim, that would not affect the ability of the landlord to go directly against the guarantee. Most guarantees provide that they do not have to pass their remedies under the lease agreement, but rather they can pursue the guarantee directly. So that seems to be a real danger for guarantors.
It is, but most landlords have not exercised that remedy thus far. Right. And, bankruptcy is the second threat to stop the landlords from exercising that remedy.
Right. It is worth your while to look and see what assets are guaranteed and what the guarantee provides. Some of these leases, if you are a tenant and it's a lease that you've had for many years, just with time, guarantee language and lease language gets a little stiffer. So if you have an older lease, it doesn't hurt to take a look and see if you do have some sort of remedies available to you.
Worthy of note is most of the guarantees that accompany leases are very, very poorly drafted, offering the guarantors some that list of 25 defenses. If you think back a decade, the 25 guarantor defenses that were advanced during the 2008, 2012 financial crisis, those have reemerged into the COVID realm. And most guarantees with lease transactions are very badly written, offering that 25 defense toolkit.
So what are some of those defenses? You don't have to recite all 25, but what's most relevant, do you think?
Several that come to mind is the scope of the waivers are often not present in those guarantees, meaning if the landlord took any type of action without the guarantor consent, the guarantor argues that the guarantor has been released as a result of the landlord's actions. That's the first and most common. The next is the argument that it's a deficiency guarantee, meaning it's not collective and several and absolute as to the entire lease payment. So there's a number of creative arguments and valid surety arguments that are advanced. So look at the guarantee very carefully. Don't assume that it's a traditional bank type of document where you have absolute irrevocable obligations to pay.
Right. So I think that leads maybe to a discussion about what, if you come to an agreement with the landlords as to a deferment abatement, reduction, extension of the lease, when you do your lease amendment, what type of things should you as both a landlord and tenant look for? As a tenant, if I'm representing tenants, of course, you make sure that the landlord is not overreaching and trying to have you surrender rights and defenses that maybe you had previously under the lease. So if there's a dispute as to condition or landlord's obligations, you want to be careful when the landlord or what in drafting or reviewing the lease amendment that the tenant doesn't waive any rights obligations or claims against the landlord. It may result in the discussion of how do we bring that to a head. But I think that is something that general waiver language in the documents, might catch. So you need to look almost as you would in estoppel. And estoppel terms are something else that a landlord is likely to sweep into the lease amendment, that there are no landlord defaults, confirming the term, especially if the term is extended or there's multiple lease amendments. It's a good way to clean things up a bit. As a tenant, you may, if the force majeure provision, and if you're a leveraged tenant, you may want to go back and expand the definition of force majeure so that it's clear that it does apply to a pandemic type of event, or even an event that's outside the control of either landlord or tenant. It kind of then begs the question is what happens if there is such an event? What happens to the lease? And if you forward think, you need to say if there's a government shutdown and the tenant is unable to operate, here's what rent they will pay. They'll pay the triple nets, but they won't pay the base rent until the whatever the moratorium is lifted. So there's those types of things that you can put into the lease, there's some other things that a tenant with leverage might ask for, such as updating your HVAC system so that it helps with the purification of the air, something more than generally when the original HVAC system was installed, and that I think is obviously for health and safety, but there may be looking forward some exceptions to shutdowns depending on the type of facilities that exists for the restaurant or retail facility. There may be some provisions where you give back a portion of the premises because you can't use it for your original intended purpose, and you may want to try to buy out of a certain number of square footage. Those types of things are something that a tenant can look to. And Tim, do you have other thoughts or ideas on items for amendments?
Yeah, I think you hit the most important one, and it's apportionment of rent and how a COVID or shutdown order affects that particular obligation in light of the tenant potentially being able to use the premises during the restricted period or shutdown period in some form. So that's a critical function. The other is taking a look at the estoppel and subordination delivery requirements, because lenders are looking at those provisions more carefully, and the requirement of estoppels have always been in vogue. Lenders always want them, but they're looking at them with a little more scrutiny of late, especially on rent deferral events especially on the COVID or force majeure language in the lease. And then that landlord lien subordination. So lenders are looking at those provisions very carefully. So the smart tenant addresses that now in their lease to facilitate the latter financing or, a subsequent financing.
And that's a key when you're doing your lease amendment is that if you have an estoppel or if you've given a subordination non-disturbance agreement, whether the lender has the obligation to adhere to your lease. There may be landlords who are unable to pay their underlying indebtedness and are foreclosed upon. And how does that affect your lease? Amendments, if not agreed to by the lender, may not be binding on the lender. So if you have a rent deferment or abatement and the lender becomes in possession, they may not have to abide by an amendment that was made without their consent or knowledge. And it creates another level of difficulty for the tenant to have to go to obtain that from the landlord's lender. But the danger is that in a foreclosure situation, a landlord, an agreement that you've made with the landlord may not be upheld. Some other ideas from the tenant side to put into your lease would be if you have if you're in a multi-use building, do you ask for the exclusive use of the elevator for your particular premises? And depending on how large of a tenant you are, that might be achievable. The issue is that now the spacing in the elevators, I believe it's, at least in Minnesota, it's 2 people because of the 6-foot restriction, social distancing. And so that's, as you open up either office or in a multi-level building, it might be something to consider depending on the configuration of your space. Landlords, on the other hand, are also going to be looking for provisions in a lease amendment. They, in turn, would likely ask for a waiver against some of the common law defenses, the constructive evictions and the quiet enjoyment, frustration of purpose, and possibility of performance, just to make it clear and to foreclose those types of arguments as that may come up as the lease extends. So the landlord's going to want to clean up those items. They are going to want to try to get the tenant to commit to whether or not there are defaults under the lease, and as perhaps a concession for the extension, try to nail the tenant down, if you will, on any type of a past default. The other piece that we see extensively is if the tenant receives PPP money or any other government type of a relief, that they pay their rent, that it would apply to any deferred rent. So that we see quite a bit. And I don't know, Tim, if you have any thoughts on whether a tenant should agree to that or not.
It's an interesting question, Pat. And in the recent deals that we're seeing a mixed result, largely a mixed result.
Right. And I think immediately, we were adamant about striking that provision because the PPP loan could also was used to pay salaries and employment, pay employees, and we did not want any of that, have an obligation, even though under the terms of the loan you could apply some of that to your rent. The primary thought was to keep the employees paid and to use the money for that purpose. But Tim, it sounds like your experience is as the PPP RFP money comes in, that some of that the tenants have been using those monies to pay some of the rent.
Yes, rent as well as those that have mortgage, the interest on those obligations. And that being frustrated by the lender itself trying to capture that money to serve as collateral for its other obligations. So we're seeing a lot of stepping over bounds, so to speak, happening with that source of money. Nothing fraudulent per se, but a lot of interest in those funds. And since the development of the forgiveness rules and the extension of time, that money being allowed to serve, other purposes or other purposes that were permitted more clearly, such as rent, right?
Yep. And then maybe the last comment on the lease from the landlord's perspective is that in the event of a default, if you come up with a structure, you will want well, two more comments. One is if the tenant defaults on the new structure that you come up with, then the deferred or abated rent will become due and payable. And in that situation, it's a bit it helps the landlord. It's a bit of a hammer over the tenant, but I think it's fair to the landlord that they made these concessions, and then if the tenant can't abide by them, and it brings the tenant back to the table and to say, yeah, we have an issue with making these payments, but they can't just, like many did, stop paying the rent. The other piece I don't want to forget to mention is if you do lower the base rent and you're in a percentage rent situation, then not all the provisions of the lease will say that the break point, if you're paying percentage rent on a natural break point, you'll want that break point to be reduced as well. I'm going to turn it over, Tim, I'm going to ask you, I know you just spoke at the Restaurant Finance and Development Conference. Is there anything from that conference that you'd like to share, trends, what you heard from that conference?
So I believe the trends, and this was several months ago. COVID was still under. Most businesses were under shutdown orders. The trend at that juncture had not yet fully emerged in terms of the multifamily sector. Since then, that sector rents have dropped dramatically, especially for the inner city locations. But I'm seeing a lot of interest with depressed pricing in that sector. People looking at opportunities to buy, even inner city. So that's interesting. A lot of the George Floyd syndrome here in Minneapolis, still exists, but people are getting more comfortable with that inner city structure. So a little soft reemergence there, but it's still largely flat. Most money looking outward in the inner suburbs for real estate opportunities. Even largely in the spaces that were super active in quick serve restaurants or fast fresh type of restaurant locations, still the focus is inner circle suburbs as opposed to the city locations. If you walk around the skyways in Minneapolis, they've been decimated. We're seeing more and more vacant boxes for really good concepts that existed prior to COVID, prior to George Floyd type of events. So the money still seems to be focused inner circle and some of the further suburbs such as Buffalo. Smaller deals are attractive right now. versus the larger projects, a little more manageable. People seem to be more comfortable with the smaller box deals due to social distancing. The number of people attending or frequenting that type of real estate project. That's in a general sense what we talked about several months ago, and we see that continuing.